Hi, my name is Anthony Upchurch, and I'll be doing a case review for Hendrick Hudson Board of Education versus Rowley. The case dates from 1982. For some background, the case was done under the Education for All Handicapped Children Act of 1975, which has in effect a policy that assures all handicapped children the right to a free and public education. So that free appropriate public education. And that free appropriate public education is assured by the setting up of an IEP for an affected student. So if you are deemed that, like if it's decided that you have a handicap, then in order to assure your access to a quality education, they set you up with an IEP just to kind of have a regulated, normalized system in process to ensure that you're getting there. Now, the state is primarily responsible for the provisions. What that means is, while this act does set up the parameters for funding, it's up to the state to kind of fill in that meat that the federal act has not provided. So the state is primarily responsible for provisions. The federal government, though, can intervene by not giving money. I mean, if they're just like, we see that you have nothing in place, then they can withhold money. But also, the federal government can exercise a judicial review. So as far as the case itself, so Amy Rowley is a hearing impaired student who is adept at lip reading. This is important. And who, with the help of an earpiece transmitter, can hear lectures. She's able to follow court documents, say about 59% of what's going on in the classroom. And despite only hearing 59% of what's going on in the classroom, she can actually, she's passing. She's at grade level. She's doing average to above average. I mean, she's an all-around good student. So, cool. For first grade, it was time for her to get her IEP set up, and she was given an FM hearing aid, a tutor for an hour a week, and a speech therapist for 3 hours a week. Her parents' request for a sign language interpreter was denied because the school did not think that she needed it. The parents demanded, as is their right, a hearing before an independent examiner, and this examiner denied the request for the interpreter because Amy was achieving educationally, academically, and socially. Parents used the EAHCA, that act from 1975. They used the provision therein for judicial review and took it to the U.S. District Court for Southern New York, saying that they were denied a free, appropriate public education. Now, the court says that the definition of free, appropriate public education is not clear, leaving it up to the courts to kind of clarify that under this judicial review. Now, here I have the definition for free and public education, or free, appropriate public education, that was provided in the Act. So get ready for some legalese. So it means special education and related services which have been provided at public expenses, under public supervision and direction, and without charge. They meet the standards of the state educational agency. They include an appropriate preschool, elementary, or second school education in the state involved, and are provided in conformity with the individualized education programs required under Section 1414A(5) of this title. Now, special education, as referred to in this definition, and mind you, this is coming from Wright's Law. It was a resource posted. It's that link when you go to the discussion board. So it's got the case name, and it's the hyperlink, and it'll take you to Wright's Law, and that's where I'm getting this information from. Special education, as referred to in this definition, means specially designed instruction at no cost to parents or guardians to meet the unique needs of a handicapped child, including classroom instruction, instruction in physical education, home instruction, and instruction in hospitals and institutions. Related services are defined as transportation, such as developmental, corrective, and other supportive services, and as may be required to assist a handicapped child to benefit from special education. All right. So now both the respondent and the petitioner, and if I haven't made this clear, because reading the case information, they consistently refer back to the respondent and the petitioner. So just to make it super clear, the petitioner is Hendrick Hudson Board of Education. The respondent is the Rowley family, okay? So both the respondent and the petitioner contend that while there is a definition for free appropriate public education in the Act, that definition is not functional. Really, it doesn't mean anything. I mean, they told you what it was, but not specifically enough for it to be able to be enacted. And that's kind of what made this whole case necessary. So there's also a question of outcome versus access. Where do you put the emphasis? Do you put the emphasis on the mere fact that they have access to an education, or do you put the emphasis on achieving the utmost out of your potential? Because we saw here where Amy Rowley was able to achieve within expected limits, well within. She was able to achieve quite well, only hearing 59% of what was going on in the classroom. So should she be given aid to exceed expectations, or is she only given aid to get to those expectations? Which, if that's the case, then she doesn't need the sign language interpreter, because she's doing fine without it. So Congress recognized in many instances the process of providing special education and related services to handicapped children, and that it is not guaranteed to produce any particular outcome. So the intent, and this is what really sealed the deal, spoiler alert, she does not get her interpreter. And the reason being is because Justice Rehnquist, in his opinion that he wrote for the court case, the intent was to open the door to access to education, not to secure any special result once inside. So the hearing aid and the tutor were enough to get her in the door, and that's all they needed. They don't need her to be able to flourish once inside the door. All they're worried about is just getting her in, which they did. As far as, because clearly I'm a legal expert, I'm not, but my opinion, I can see where we would all feel better if everybody were given the most amount of resources that we could possibly have. Like, I would be more comfortable with her having the interpreter even if she doesn't need it to pass by. I mean, if she is a super bright kid and we want that super brightness to be potentiated, then yeah, totally give her sign language interpreter. But I could see maybe where the point, I guess it's the difference kind of between legal and ethical. Ethically, I think that she should have been given the interpreter for the simple fact that if she was getting 59%, that means that she was missing 41% of what's going on. And why would you even set up a kid knowingly to miss 41% of what's going on if you know that it's so totally preventable? But also, the idea that government, just as a whole, may not be the best tool to secure educational goals is an argument to be made. I mean, clearly, we have a decision, so it's not really like what I have to say on this discussion board matters, but I could maybe see the point, I think, of like a a limited government type, like, limited resource. I don't know. I'm really trying to see their point of view. Their point of view really was that the act just gets you inside the door. It doesn't necessarily control what you do once you're in. I mean, I think it's a cop-out, to be dead honest. But men much more educated and well-versed in law than I would disagree. So, I mean, if you're going to defer to anyone, I would imagine that I would defer to a Supreme Court justice. Anyway, that's the law case. Pardon my rambling. I really am. I do struggle to see how that terminated. I mean, like, you can follow the path from point A to B to see how it terminated that way, but it just didn't really seem like it would. I mean, I just would have thought something different. Hey, thanks for your time. Thanks for paying attention if you did. I don't blame you if you didn't. And feel free to ask any questions or leave any remarks, and thanks a lot.